My lord, may I be permitted to mention for listing one compensation appeal?
Okay, in the month of January.
It is ready for hearing.
Yes, yes, January.
My late to mention
an application for our inclusion in the list, my lord.
my
Same January.
my same.
Yes.
Application, my lord.
All month of January.
My lord, may I mention a matter not in your lordship? Your lordship directed the matter to come on 11th.
11th, second appeal.
Yesterday.
Second appeal.
Application.
Yes.
Now, it was not listed yesterday. Today also it has not been listed, but your lordship has.
You are for the appellant.
No, I am for the respondent. What happened? The appeal has been filed in the name of a dead person.
Anyway, let it appear in the month of January.
No, but what happened? Your lordship has passed an order that the parties will seek adjournment, and the execution case is being stalled there because of this order.
No, when is the next date fixed?
Yesterday it was there. This way the appeal which is admittedly against a dead person.
No,
How
no.
can an order be
So
passed?
let your learned friend take instructions. Like,
He has filed, your lordship, what the appellant has filed a section 47 application in the trial court. In that,
no, question is, are you holding a power on behalf of a dead person?
no,
on the last of
no,
the
That is the question.
person is the
they appear
respondent.
on
Dead person is the?
Respondent.
Okay.
Plaintiff respondent is a dead person. Kindly see the section 47 they filed there in the trial court, where he has substituted the appellant.
Question is, let it come in the month of January. I shall take it up.
Lordship, that interim order is there.
Okay.
Yes,
When is the next date for execution case? Prior to that date, the matter will come up.
Yesterday it was there in the execution case. It is
No. Yesterday it was appearing before this court.
No, in the trial court.
When the matter was within the list, you didn't appear.
Yes.
You appeared.
Your lordship
So did not point
on 11th.
Yes, very well. 11th of January.
No, December. It did not come. Yesterday it was fixed. No,
That
it
means
did not come. Today also it has
that
not
means
been.
when the matter was there, in your presence, that order was passed.
Yes,
So,
but there was no copy served on us.
Yes,
So we did not know what was the cost title. Section 5 application was before your lordship.
anyway, on the next day, your learned friend will take necessary steps. Let it appear on the next day.
But your lordship, this without the matter be section 5 without admission, how can an order be passed?
That I shall
appeal?
that I shall consider on the next
Without
day.
admission, without
See,
substantial.
You see, that's a different issue. There are different decisions on that. I shall consider on the next day. Please come on the next day after vacation. I shall take it up. Yes, let this matter appear. Hey, give the slip. It will appear either on 5th or 6th.
Your lordship,
Has to be mentioned.
There is an order passed by your court, and the court officers are not following that order.
No. They have to follow.
Why the matter has not been
Yes,
listed?
list it either on 5th or 6th. Has to be mentioned.
Specific order is there from court. It is not being listed.
Judgment item number
My lord, 1 minute.
Yes.
May be permitted to mention, my lord, item number 34 and 35 of today's list, my lord. My lord, it is, my lord, that analogous matter. I am just mentioning it because for fixing a date of hearing, my lord.
34 and 35.
It is under the heading hearing appear, but my lord, specific date may kindly be fixed, my lord.
Who is appearing for the other side? You are for the claimant appellant.
I am for the claimant appellant.
For insurance company, who is appearing?
Rajesh Singh is there.
34, 35.
34, 30. Shoma. Only if I am fixing a date, my lord. Because it will never reach.
No. What is the urgency?
They are suffering, my lord, a lot, my lord. That is why
The
doctor
2024 matter, what is the urgency that immediately you want the matter to be heard?
Any day, my lord. Any day it may be fixed, my lord. At least fixed, my lord. Otherwise, it will not reach, my lord.
Okay, let it appear on, yes, item 34 and 35. Let it appear on 8 তারিখে কোনো ফিক্স ম্যাটার আছে? হ্যাঁ 8 তারিখে let it appear on 8 within first 5 matters. If you are ready on that day, I shall take it up.
Yes, sir.
You tell me whether you will be ready on that day.
The first week and second week, your lordship will kindly see my lord's diary, my lord, how many matters are fixed. My lord,
আচ্ছা তাহলে এক কাজ করুন এটা 13 if both of you are ready, you can mention also, I shall take it up.
Yes. 13th.
grateful to you.
For judgment item number 1 and 2.
Yes, hence FMA 1044 of 2024 and COT 22 of 2025 stands dismissed. The judgment and award dated 22/5/2024 passed by the learned Additional District Judge Third Court Kamluk, Purbo Mednipur in MSC case number 76 of 2021 is affirmed. Claimant respondents are entitled to withdraw the awarded sum upon compliance of all formalities.
DP of Judge.
Along with accrued interest.
Yes, whatever is the deposited, they have deposited with the interest.
That amount is
Yes, whatever is, you see, whatever they have deposited in terms of the order passed by the learned trial court, that you are entitled to withdraw.
Lordship. But Lordship, they are deposited earlier. Same has been invested in the in nationalized bank pursuant to the honorable court's order. So some accrued interest will be there on. If Lordship will pass, they will not that. It's very few amount, but it will lying with the bank authority. But
Whatever it is, the register is to deduct whatever there are
no,
the
no, so
procedure.
only along with accrued interest, if any. Just
That
just
is not
alone.
necessary. Okay.
Other-
Just you withdraw. You see, whatever I am passing in all other matters, this is the same.
Otherwise, Lordship, I have talked with them. Otherwise, if Lordship directly knows, otherwise Lordship will
I don't know anything.
at that way, then they will not allow us to withdraw because of if Lordship is a few amount. But Lordship, I'm informing you, Lordship, in so many matters, some few amounts still lying with the bank authority unless the Lordship will pass the order. Because we will not come further because the amount is very few. If
I have made
if
that.
any, if any accrued interest, if any, just to slide.
No, is that done in other matters? That
All
accrued
the
interest?
matter, all the matter.
Yes, Mr. Singh, is that done in other matters, including that accrued interest?
My lord, since my lord has been kind enough, my lord, to dismiss the bill as well as cross, and your lordship needs on the idea, my lord, that the whatever amount insurance company.
Whatever you have deposited in terms of the award passed by the trial court.
My lord's mind, my lord, is that whatever amount is deposited before the court, claimant should get in its entirety. So, my lord, whatever amount is there before the court, my lord, it is also accruing interest somewhere. So, my lord, sometimes my lord's officer are in confusion, my lord, that whether interest is to be given or not, my lord, whether it is our refund or whether it is given to. So, if my lord's one word, my lord, would clarify everything.
Yes, because unless there is some modification of reduction, the insurance company will not get anything.
So, lordship will kindly, my lord, clarify the amount deposited by the insurance company along with the my lord, along with the interest subject to, my lord, the deposit of the appropriate court fee should be given to the. my lord,
Yes, upon
claimant.
compliance of all necessary formalities. So awarded some including the interest
Lordship.
accrued.
আমাকে আমি জজ নই, দর্শক ওইখানে আছে। I'm extremely grateful to you.
DP of Judge.
Okay, including interest accrued.
Yes, if any, Lordship, if any. I'm a blood.
I'm for the petitioner, when applicant is not present. Hearing of this application was concluded. Thereafter, my lord was kind enough to send the file to mediation failed.
Okay, not today, in the month of January.
তুমি জানোই না অ্যাপিলের ভ্যালু কত লিখতে হয়
আরে দূর বুঝে নাকি সমস্ত অ্যাপিলে ভুললে
তো not this week আছে।
Item 5.
Yes.
Yes,
Item
what is
5.
the correction?
My lord, claimant's name will be Deepali Man, my lord.
Dipali Manna?
Man, M-A-N. And my lord, Registrar General will be directed to release the entire amount lying deposit.
In the order, the claimants that man will be added and registrar is to be directed to release the entire amount in favor of the
He has
claimants.
been written some, my lord, words. My lord,
let me
kindly
see the order.
Yes, yes. ভেতরে আছে, হ্যাঁ।
ওকে জিজ্ঞাসাই করেনি
Page my lord 8. Page 8. In the cost title, it will be Deepali Mon.
বলছে তোমার নাম ও যেন পাড়ার লোকের নাম বলছে
Okay, so in the cost title, it should be, oh, it is
So that-
just Dipali.
Yes, yes.
Yes.
The surname has to be added.
And others are all, other claimants are okay.
Yes.
Withdraw the entire amount deposited in High Court along with accrued interest. Yes, record an order. Learned advocates for the parties are present. This matter is put up for necessary correction in order dated, in judgment dated 3rd December 2025. Stop. In the judgment dated 3rd December 2025, the name of the respondent number 1 be rectified as correct and corrected as Dipali, D-I-P-A-L-I, M-A-N. D-I-P-I-L-I আর টাইটেল হলো M-A-N, আলাদা করে। In the last paragraph of the judgment, where the respondents are permitted to withdraw the entire amount, it should be rectified and corrected as the respondents to withdraw the entire amount deposited in High Court along with accrued interest. Stop.
And registrar to release it.
Learned Registrar General.
After compliance.
Learned Registrar General is requested to disburse the amount in favor of the claimants upon compliance of all formalities.
My lord.
Other contents of the judgment and order dated 3rd December 2025 remain unaltered.
Grateful, my lord.
Item number 6.
And the
আবার কেন কি হলো?
FMATNP. So matter is due to appear on, matter is due to appear before the, okay, 7th December. No, it should be 7th January. Some correction is already made earlier.
আবার কি হচ্ছে?
এর আগে একটা কারেকশন হয়েছে তো, এই 7th December,
হ্যাঁ।
পুটাপের জায়গায় 7th January হবে।
ওটা বলে দিন। হ্যাঁ?
হ্যাঁ?
ও এরা ভুলভাল নাম্বার দিয়েছে, ইনস্ট্রাকশন থাকে না। আমি কেন এমবি দেবো? তুমি দেবো যে তোমার
7th December এর জায়গায় 7th January।
তোমার এখন কথা বলছে।
আমি ভুল দিয়েছি।
হ্যাঁ।
আচ্ছা ঠিক আছে। Yes, record an order.
ভুলভাল নাম্বার দিয়েছে।
জজের নামে ভুল হয়েছে, আমার কোথায় ভুল হচ্ছে?
Learned
ভুল করতে পারে না।
advocates for the parties are present. The matter is put up for
ভুল করতে পারে
necessary
না।
rectification of order dated 1/12/2025. In paragraph
বলছে?
5 of the order, instead of FMAT within bracket MV,
ভুল করেছে।
which is not recorded, let FMAT MV 212 of 2025 be rectified and recorded. Stop. Other contents remain unaltered.
অর্ডারে ভুল লেখা হয়েছে।
যশে ভুল করেছে তুমি বলছো? যশে ভুল করতে পারে।
Number 8.
For the claimant's evidence. There are two applications. One is recording date and another for passing appropriate order. Claimant respondent number 2 herein, Bijoy Kumar Pal, my lord, died during pendency of this appeal. So his name may be deleted, my lord. Other legal heirs are the
That is can 1.
this is can 2.
Eta can two.
Can 2.
Can one this.
And can 1?
Can 1, my lord, for passing appropriate order. My lord, Jamuna Munmun Pal, one of the claimant's appellants, my lord. After marriage, my lord, her name is appearing in the records as Munmun Banerjee. So only this.
So item this appellant number 2 died. And the heirs are?
Yes, sir. My lord, appellant number 1 and 3, they are mother and elder sister.
1. That is no, appellant number 1 is this Bijoy Kumar Pal. Appellant number 2.
2. He has expired, my lord.
So the heirs are?
Already
1 and 3.
1 and 3 already on the record.
Already on the record. It should be recorded, my lord.
Yes, record and order. Learned advocates for the parties are present. This application, can 1 of 2025, is filed for recording the death of appellant number 2, Sri Bijoy Kumar Pal. Stop. The appellant number 2, Bijoy Kumar Pal, died during the pendency of the appeal, leaving behind the appellant number 1 and 3 who are already on record. Stop. Thus, the name of appellant number 2, Sri Bijoy Kumar Pal, be deleted from the cause title. Stop. The amendment be carried out within 2 weeks. Liberty to mention.
And my lord, can 1.
Can 1. No, this is can 2 I took up.
Yes.
Oh no, this is
Can
এটা
2.
can 2 টা হবে।
Can 2.
হ্যাঁ, তাহলে can 1 টা আগে
Can
করে দেবেন।
1.
Yes, this can 1 of 2025 ওটাকে উপরে দেবেন এটাকে is taken up for consideration. The applicant has prayed for rectification of the name of the appellant number 3. Stop. The appellant number 3 is Munmun Pal, but it is wrongly recorded as Munmun Banerjee.
No, after
No. After marriage, my lord, she,
surname was
The
Munmun.
name of the the original
Munmun Pal.
Munmun Pal. Okay.
Now she
Let it be
became,
recorded as Munmun Pal as well as Banerjee.
my lord, her every records, my lord, shows Munmun Banerjee. Otherwise, my lord, if my lord, my appeal is allowed.
Thus, কি লিখলাম মানে the name for rectifying the name of the appellant from Munmun Pal to Munmun Banerjee. Stop. It is the contention of the applicant that pursuant to our marriage, she is known as Munmun Banerjee, for which this particular application is being made. Stop. The documents of marriage is
Yes.
annexed to this
Yes.
petition. Thus, this application stands allowed. Let the name of the appellant number 3 be rectified and corrected as Timothy
Munmun Banerjee.
Munmun Banerjee.
Along with her residential address present, my lord, I have already described in para 4 in my prayer, my lord.
Along with her residential address
Right.
as mentioned in paragraph 4 of the petition.
Right.
The amendment be carried out within a period of 2 weeks, liberty to mention.
My lord, great. ঠিক আছে নামগুলো দিয়ে দিও না
হ্যাঁ নাম দিন।
The register ke পাঠিয়ে দিয়েছি to trace out the file. If found, send it to the local adalot. হ্যাঁ না যেহেতু ম্যাটারটা লিস্টে নেই Huh? No, Dui as well as one. 2 and 1, both are disposed.
Nine, my lord, I am appearing on behalf of the applicant insurance company, my lord. There is delay in this matter. Very humbly, my lord, the execution, why I mentioned.
You have served.
No, my lord, I'll just, my lord will hear me out for a moment, my lord. The difficulty is it's a changed brief. Today, the date for execution is fixed.
Very well, I'm granting
shall
you
serve.
opportunity
Yes,
to
yes,
take adjournment there and fix the matter after vacation.
my lord, my lord. In the meantime, I shall serve.
Yes. Yes, record an order. Learned advocate for the appellant is present. Let the copy of the application under section 5 of the Limitation Act and the application for stay be served upon the respondents. Stop. Let this matter appear on 14/1/2026. As the matter is sub judice before this court, the appellant may seek adjournment before the learned trial court / executing court, which may be considered.
That may, my lord, may will create problem for me, my lord, kindly.
In all other matters, I'm passing this
My,
order.
my lord appreciates, my lord. It's a change brief. I
Okay,
just got it. That may,
which is to be considered.
my lord, grateful, my lord. Siddhartha, thank you.
10 and 11.
10, 11, my lord, I am for the claimant respondent and the cross objector. My lord, my one application, CAN 2 is pending, my lord. This application has been filed by me for withdrawal of 60% of the awarded amount deposited by the insurance company. CAN 2. CAN 2, টাকা withdrawal is only. The appeal has been filed by the insurance company, my lord, only for the ground. Only there are several grounds, my lord. Main ground is that 7.5% per annum interest has been allowed by the trial court. An insurance
Please,
company.
this is the ground or other grounds are there.
Other grounds are there, Your Lordship.
That is
My
depend-
stay needs to be made absolute. There's the affidavit of service today I'm filing, and along with the challan copy showing the entire amount has been deposited, Your Lordship. Your Lordship, the
7,69,000? No, 76 lakh.
76 lakhs 98,035 rupees.
No, it will be made absolute. Now, how much you are agreeable for him to withdraw?
Nothing right now, Your Lordship. This application could be disposed of with the original appeal.
I am staying this order, but you come with necessary instruction on the reopening of the
Your
court.
Lordship,
How much you are ready and agreeable?
Your Lordship, kindly fix
the grounds, my lord.
Your Lordship, kindly fix the entire appeal,
is-
and it could be disposed of along with the application, the
There
CAN application filed by them.
It will
Because
take
if
time.
the
Okay, let this matter appear on the same day on which I have fixed the other matter of yours.
yes, yes.
I probably have kept it on 13th or something.
On 13th, my lord, you have
Probably.
lordship
So
has-
let it
Yes.
appear on that day.
Day after, my lord. There are one day after or before, my lord. It will be better, my lord.
Achha, record an order. Learned advocates for the appellant. Learned advocates for the parties are present. As the appellant insurance company has deposited the entire awarded sum as directed by the learned trial court along with interest, the judgment and award dated 20th December 2023 passed by learned additional district judge, Fast Track Court 1, Alipur South 24 Parganas in MSC case number 486 of 2021 shall remain stayed till disposal of the appeal. The learned advocate for the appellant insurance company is requested to come with necessary instruction with regard to the application filed by the claimant respondent being FMA. That is
FMA.
CAN
2 of
CAN 2
2024.
of 2024 for withdrawal of 60% of the awarded sum.
Yes.
Let this matter
Your Lordship,
appear on 15/1/2026.
Your Lordship,
come
but-
with instructions.
The cross objection.
Your Lordship, a direction to be given to them to file to give us supply a copy of the CAN 2 over the
Right, all right.
Yes, you supply a copy.
Yes.
Otherwise, how will you take
I'm
instruction?
against supplying.
My lord, I'm sorry to trouble, my lord.
I'm
Once
against
again, my lord.
Yes,
In the last matter, item 9, my lord.
yes.
Today, since the execution case is fixed and my lord won't be there, let the order be uploaded today, my.
Yes, yes, that will be done,
Okay.
definitely.
I'm grateful, my. And will my lord be kind enough to record the number of the execution case in the order? 1 of 2025.
আচ্ছা এটা নিয়ে আসুন তো আগের আইটেমটা হোয়াট ইজ আইটেম নাম্বার
9, the last item.
9টা নিয়ে আসুন আচ্ছা ওখানে কি লেখা আছে দেয়ার শ্যাল বি এ লার্নেড the appellant insurance company may seek adjournment before the learned trial court stroke executing court in what is the
Execution case number 1
in
of
execution
2025.
case number
1 of 2025. And
1 of 2025 pending before the learned trial court stroke executing court.
that may, my lord, has 1 second. May.
Acha, no, may from your side, which should be considered.
I'm grateful, deeply obliged, my lord.
My lord, 12 is appeal of insurance company. My lord, today is appearing for the first time. My lord, my learned friend is appearing on behalf of the claimants. My lord, there is a
Vehicle owner is served.
my lord, vehicle owner. My lord, I have served. My lord, they have not received asset. But my lord, this appeal is only on the quantum. My lord, no other point of law is involved. My lord, my lord, the vehicle owner. Otherwise, my lord, I am not paying any relief against the vehicle owner. This is only confined to the quantum. My lord, there is a delay of my lord 284 days.
No,
My lord.
this is which application?
Item 12, my lord.
Item 12 can
1 and 2, my lord?
1 and 2. One is for section 5.
One is my lord section 5 and 2
and
is
which
my
is
lord
for stay.
and 2 is for stay, my lord. My lord, I'll just indicate, my lord. My lord, condonation of delay, my lord, is can 3. My lord, condonation of delay is can 3. And my lord, stay is can 1.
Stay is can 1.
Lordship.
Can 3 is condonation of
Can
delay.
3 is condonation of delay.
Okay.
My lord,
How much is the
my lord,
delay?
284 days, my lord, on behalf of my client.
208?
My lord, initially, my lord, I had filed this appeal, my lord, with this true copy of the award. But my lord, subsequently, my lord, certified copy was taken, my lord, and my lord, we have filed the certified copy.
Yes, let it be condoned.
My lord,
No,
my
my
lord,
lord,
may I-
I usually would never oppose a condonation of
Yes.
delay application, but in the facts of this case, considering that immense malafide on the part of the
Okay,
insurance
then you want to file your opposition.
I want to file my opposition.
Now, if this is not admitted, the stay application will not
There's
be
no-
taken up. Okay.
Lordship.
Now the question is, don't proceed before the trial.
Your
court in
lordship
the
will kindly
future.
My
record
lord,
that. my lord.
it's all come to an end. May I indicate what the
Yes.
facts are? My client has received compensation because of a certain accident, received a compensation of 14 lakhs.
Yes.
My lord, the additional district, the MSc tribunal, and which is the additional district judge, my lord of First Court Alipur, has heard out the entire matter on merits
Yes.
and has given a final award, a compensation of 14 lakhs 2,615.
Yes. And how much you have received?
With interest. Nothing, Lordship. Nothing.
Very
This
well.
appeal, now this appeal has been filed. No steps taken to move the appeal. Every time the appeal has been taken up, I have the series of orders, only times being taken.
Now, question is, have you instituted an execution case?
My lord, we have not instituted an execution
So,
because
so
the
wait.
person has passed away, Lordship.
Okay.
Because of causing this delay,
No, no. If
The-
you want to object, then you
Lordship.
come with your affidavit in opposition. Let me
We'll-
decide on merits.
my lord, at least let them make the deposit because that's the law. They
How
have
can
to
they
make
make
the
deposit? You see,
Lordship.
if they make a deposit, that
My lord.
stay application has to be taken up. Unless this section 5 is condoned,
Lordship.
the appeal is admitted.
Lordship.
You consent to this?
Lordship.
I shall ask direct them to
But I'll
deposit.
deposit, my lord. I'll deposit.
Because you are not even because you are not ready now to deposit the
My lord,
25,000.
my lord, I have deposited 25,000. I have given the receipt to my lord's officer. My lord, I'll,
The
my lord,
awarded amount has to be
my lord,
deposited.
may I just
That Mr. Singh will deposit within 5
Yes.
weeks.
Yes,
The
I shall.
entire amount. Lordship.
Yes, I think you are not aware
My lord, that
with
if
this
no,
procedure.
because in the previous hearings, Lordship, there was no whisper of making any deposit. They
Anyway,
were not. If
so
that is the
let
case,
the delay be condoned.
Lordship,
Let Mr. Singh deposit within
the
5
entire
weeks.
amount, Lordship,
And if it is deposited, it will continue.
Lordship,
Grateful, your lord.
Please record an
with
order.
interest.
Learned advocates for the parties are present. The application under Section 5 of the Limitation Act, being Can 3 of 2025, is taken up for consideration. Heard learned advocates, peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that the petition that the appellant has been able to furnish sufficient grounds for condonation of the delay. Thus, delay in preferring this appeal is condoned. The appeal is admitted. Stop. The application for stay being CAN 3. What is this CAN 2 for?
Milord, CAN 2 is not my application.
আচ্ছা CAN 3 টা দিন তো CAN 3 টা কোথায় আছে?
হ্যাঁ?
না না stay এর application 3 টা হয়ে গেল dispose. CAN 3 is disposed. Appeal is admitted. CAN 1 টা দিন।
CAN 2 টা কি? তোমরা ফাইল করেছো তুমি জানো না? আমরা ফাইল
Stater.
অ্যাপ্লিকেশনটা নেই নাকি ইয়েতে?
Well, CAN 2 was our application to, because they were delaying the matter, we wanted the matter to be taken up and the deposit be made, which is why we filed CAN.
Now, learned, the application CAN 1 is taken up for consideration as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be an ad interim order of stay of the judgment and award dated 11th day of July 2024, passed by learned additional district judge, First Court, Alipur, South 24 Parganas, in MSC case number 371 of 2005 for a period of 5 weeks. Stop. In the event the appellant insurance company, the appellant insurance company is directed to make the entire deposit of the awarded sum along with interest as directed by the learned trial court, excluding the statutory amount deposited within the period of 5 weeks. Stop. In the event the entire awarded sum is deposited within the period of 5 weeks, the ad interim order of stay of the judgment and award of the learned trial court shall continue till disposal of this application. As the respondent, your respondent number?
But I'm the claimant.
Yes.
One, my lord, respondent number
1 claimant has entered appearance. Service of notice upon the respondent number 1 claimant is dispensed with. So vehicle owner is to be served.
Milord, your lordship will kindly record, Milord, since this appeal is only confined to the
Anyway,
quantum.
I'm not
Lordship,
recording.
lordship,
Liberty to mention.
lordship.
My lord, may I make one small prayer, lordship? My lord,
The Registrar General, ওটা লিখে দেবেন আর কি. Yes.
my lord, can the stay be for a particular period? Otherwise, lordship, this matter will be very difficult to get it heard and disposed because
You see, if there is a contingency, if Mr. Singh's client fails to deposit within 5 weeks, it will not be
no,
extended.
my lord, even after the deposit, lordship, kindly envisage the situation. My lord, in fact, my client who was actually the recipient passed away because of all the delay caused by them.
Which year case? Case of?
2005, it
No,
started.
this appeal.
This is 2024. My lord, in this long attempt to
Award
delay,
passed in which year?
my lord, 2024,
2024.
lordship.
So what is the
My lord,
delay?
but that is the delay is lordship in my client getting the compensation for 20 years he's not been getting
In
it.
the appeal court, there will be not much delay.
My lord, but already so much more than a year lordship has been taken in taking a widow with son studying cannot afford education.
If you have come earlier, I could have sent the matter to Lok Adalat.
But it is
for
only
3
on
weeks
quantum,
ago.
Milord. It is on quantum.
Yes, the
My lord,
matter
lordship will
would have
kindly
been settled if you had come earlier.
My lord, every time we tried to do that, time was taken. And that's how this matter has been pending for
Because there is no time. Tomorrow is the Lok Adalat.
lordship.
Anyway, liberty to mention, you mention it or either you
My
can
lord, at
mention
least
it also.
kindly fix the time of stay for a particular period. My lord, that's my only
You
prayer.
see, if the deposit is not made within 5 weeks, it will automatically lapse.
No,
If
my
both of you are ready, I shall take it up in the 3rd week of January.
lordship, kindly do that. Kindly keeps it on any
You
date.
mention it. You mention the matter in the month of January. Definitely, I shall include it. I shall give priority also.
Lordship, these are impoverished people, lordship. We are just trying to help them out, lordship. The family was driver my lord, can't afford, the widow can't afford to manage the family even. And the person who passed away,
You have waited for so many years, just wait for 4 weeks.
my lord, grateful.
Obliged, my lord.
My lord, in item number 13, Mr. Shwani Chakraborty is appearing on behalf of the respondent number 225, my lord. My lord, I'm praying for not today on her behalf. She's
So what is this application? Can
my
3?
lord, can 3, my lord, has been filed by them.
Can 3 filed by us, my lord? That is,
You are the appellant.
I'm the appellant, my lord.
So is there any urgency?
No, my
Let them
lord.
serve
So anyway, not today.
But let them serve a copy of that application.
Application, yes,
I-
serve them a copy.
I will,
please.
my lord.
Gratefully.
During the course of the day only.
14, my lord, I'm for the petitioner led by Mr. Chittupriya Ghosh. There is an application for grant of leave to present the memorandum. Can 2, my lord.
Can 2 is for?
For grant of leave, my lord.
Leave to prefer the appeal.
Yes, my lord.
Service upon the opposite to other parties are complete.
My lord, there is a delay application also for
So
services.
unless that is served,
No.
yes, record an order.
Kindly grant the leave application and direct to serve the section
Whatever
5.
it is, the leave application has to be considered as along with section 5. Okay.
Okay.
Upon hearing the other side. Okay. But you have not served the other side.
No, my lord.
Yes. Learned advocate for the appellant is present. Let copy of the application under section 5 and the application for leave to prefer the appeal be served upon the respondents. Let this matter appear. How soon can you serve? Okay, serve the respondent within 1 week and affidavit of service be filed forthwith. Let this matter appear on 15/1/2026.
The item number 15, this is my application, madam. Affidavit of service, madam. Madam, the plaintiffs of the appellant before the lordship, madam, this is an application for injunction. Madam,
No, can 1.
Can one, my lord, what happened, my lord?
No, service upon the matter is admitted.
Appeal is admitted, my lord. We have filed an application for injunction, restraining them from not to disturb a
No,
petition.
injunction is granted by the appeal division bench.
No, I tell you, lordship, my lord, on that day when the matter was taken up for hearing, the learned caviator was not present because he was engaged in another court. The court asked me to serve and approach the learned trial judge for the fresh interim order. I approached Justice Grace Court, my lord. On that date, he was also not present, my lord. That matter cannot be heard. My lord,
So you are the plaintiff appellant.
the plaintiff appellant, my lord. The appeal is made. I give you a short facts of the case, my lord. What happened, my lord?
No, you see, this is an application for injunction. It has to be decided on affidavits.
My lord, let them file everything. In the meantime, kindly protect, my lord. They should not disturb my position, my lord. Your lordship kindly seize the order.
Kindly see the prayer of the application, my lord. Kindly see the prayer of the what is, whether this is injunction or this is stay of operation.
Your lordship can always mold the prayer, my lord.
No, what then?
What is this
How can I
application?
file affidavit in opposition?
Stay of
Stay of the operation of the.
We always ask for stay of the operation.
My lord, this is a.
No, when the division bench admitted your case,
Yes.
some interim order is already passed. Let me see the order
Yes,
of admission by the division bench.
Yes, kindly division bench order. Your lordship kindly sees the order dated 17th of October 2023. The main issue in controversy.
Let me see the
Yes,
order.
they can. 17th of October 2023, the appeal was completed under Order 41 Rule 11.
Yes.
My lord, another thing, whether service has been completed or
Yes,
not,
yes.
my lord, kindly.
No, you are the caviator. Okay, you have been served.
No, my lord.
So question is, you have been served.
No, this is informed through.
Admission is made without only serving you.
Yes,
He
yes.
has only lost the caveat. Thereafter, my lord, we have served all. My lord, this is evidence.
Whether affected or
No,
not.
but this is can 1.
Can one. No, he's taking always the technical prayer before Lord. He doesn't appear when the matter is taken up for hearing.
No notice has been given.
What notice?
কবে notice দিয়েছে?
No, what is the order passed by the trial court dismissing your case?
Yes.
But dismissing the suit, holding that the CS record of right will not prevail.
Now the question of there is no stay of cannot be stay of the decree.
My lord, I stay of the decree, my lord, the stay of the operation of the judgment, the decree of state before your lordship will kindly.
No, question is stay means what? There cannot be any execution now.
Parliament injunction, my lord, the injunction order cannot be stay. I stay, my lord, in the meantime.
So why don't you file an application for injunction?
My lord, in the meantime, my lord, your lordship kindly.
No, what can I do? Well, let me see. Where is the interim? Where is the order of the division bench?
Order of the division bench, yes, your lordship. My lord, kindly seize this order, my lord. The caveator was served, he was not present. The matter was taken up for
Let
hearing.
it just with the land. So it is admitted, okay.
Yes, admitted. And the matter was moved and his lord, their lordship was.
Okay, there was a direction to serve the application for stay.
We have served all.
Affidavit of service.
Now, what was your suit for?
Tell you, Lordship, give me 5 minutes time. What happened? The plaintiff filed a suit for declaration that I'm the owner of the property. Case recorded owner was my grandfather, and we inherited the property from Sheikh Tamujuddin, who was my in. And my lord, the defendant was interfering with my possession, my lord. We have filed a suit for declaration with a prayer for permanent injunction. The defense was that they are the RS recorded owner, therefore. The RS record of owner will have a prevail. The record of rights will prevail over the case record of rights. The trial judge dismissed the suit, holding that since I am a case recorded owner and he has produced a deed which is subsequent in nature, the RS record of rights will prevail.
Now your suit was for declaration and injunction. So that is dismissed. And during the pendency of before the first appellate court, you were enjoying any order of injunction?
Order was there. Interim order was there. Interim order was there, my lord.
Thereafter, appeal also dismissed.
Yes.
No, that is why I am asking. In the before the appellate court, was there any
trial court decided that I am in possession? Trial court decided that.
Yes, so his suit was dismissed.
Suit dismissed. Thereafter, appeal dismissed. Then
what is the what have you stated? No appeal. No. During the pendency of the first, during the pendency of the first appeal, was there any ad interim order of injunction?
Ad interim order of injunction was there, restricting them for not to disturb my possession.
During the first appellate court.
Yes, status quo order was there. Thereafter, my appeal was dismissed, holding that I could not prove my case. And my lord, my humble submission before the division was that the court was misconstrued the document because the case record of rights is a document of title. Under the Bengal Tenancy Act, my lord, your lordship knows these type of documents that it exhibits 2 series. The column is Shamil Dokol Shotto. That means this is a Nishkot Jomi which is rent free. That means this is a document of title. And the court, having considered this particular aspect of the matter, my lord, my submission, the court admitted the appeal.
But according to you, you are stating that you should not be dispossessed in the meantime.
Yes, my lord, this is my humble prayer.
Kindly see the page 34 of the trial court order.
Page 30.
Trial court order, my lord.
The appeal will become infructuous. That has been held by.
My lord, he has not filed the injunction application. This is stay. If stay is allowed, that means appeal would be allowed.
I'm not asking for stay. Kindly modify the order, my lord.
My lord, he has filed the injunction application.
Where is the order of the appellate court?
My lord, kindly.
No, appellate court.
Page 34 once, my lord, last 2 lines.
My lord, no title has been produced by both the parties. He'll also kindly seize the order.
Page 34 of the petition.
Of the memo.
Page 34 of the memo.
My lord, of the petition.
Just a minute.
Of the petition. The order of the trial court, last 2 lines. Ordering portion. So the plaintiff have failed to prove that they are in possession in the suit or they are in interest of the had any interest of the suit property.
This was the wrong done by the appeal court. That is the reason the appeal was filed.
That has been affirmed by the appeal court. That has been affirmed by the both the court affirmed it.
My lord, kindly seize the judgment. My lord, I have made out the prime facie case that this particular document has been wrongly interpreted by both the courts below. That is the reason that the appeal was admitted by the division bench.
If they file the application for injunction, I will file, my lord, affidavit in opposition. My lord,
the status quo to be maintained by the parties in the meantime. Let him file an affidavit in the meantime.
My lord, this is the application for stay. If my lord granted stay, my lord, the appeal would be allowed.
My lord,
appeal would be allowed, my lord.
Both the sides are in position, my lord, he will not be prejudiced if the status quo is passed regarding nature and character and possession. But well, kindly consider one judgment of these. I argued this matter. Your lordship will doesn't pass an order. In the meantime, I am dispossessed of the property, my lord.
Yes.
You should cause immense hardship to my clients. When the appeal is pending consideration before your lordship's court.
Once a appeal is admitted,
And
My lord, how
when
they
the-
have said that they had been dispossessed, both the court decided in my favor. They are need on in possession. That is when affirmed by the trial court.
The appeal is admitted before this.
Maybe appeal had admitted.
Not
Whether I am in
The
possession.
question is, that was the original suit was under the specific relief act, that is declaration and permanent injunction, not a question of the mandatory injunction. So regarding that, the suit is dismissed and it is affirmed by the appeal court. Against that, they have come.
Whether kindly see the plaintiff failed to prove that they are in possession. They have not in possession. Both the court.
That is the wrong. If the reason appeal has been filed before this court and the court
Both the court
admitted it,
affirmed this.
that is pending consideration. They have made a mistake by both the courts below.
appeal has been admitted on the ground.
Will also kindly seize the appeal court judgment once. Kindly counsel neither. Please kindly
দিয়েছি তো ওখানে দিয়েছি অ্যাডমিশন অফ অ্যাপ্লিকেট ইয়েটা দিয়েছি তো
see the first ground what the division bench has formulated. You also kindly seize. When the learned judges of the court will have substantial are in law in refusing to decree the suit filed on behalf of the plaintiffs, holding that ROR produced on behalf of the defendants being subsequent to the says ROR produced on behalf of the plaintiffs and a subsequent document of possession would prevail is erroneous, my lord. The court has formulated a document, formulated this question.
My lord, subsequently they have amended recovery of possession. What is the prayer, my lord? In the my lord, kindly see the plain copy of the plain.
Just a minute.
My lord, page. My lord, page 18. Page 18, prayer C.
Page 18.
Page 18, prayer C. For recovery of possession. That means they have not in possession.
Which page? Just
Page
can one?
1818
No,
of
no,
the
can one application?
application.
Page 8.
Page 8, prayer portion of the plain.
Page 8, yes. No, this is the application.
Yes.
No. Amended plain, my lord, page 18. Application, page 18.
Which application? Can one?
Can one.
Can one, page 18.
18.
Yes, this is the amended plain.
Yes, my lord, point number 13, prayer C. Kindly see the prayer C.
Okay, prayer C.
Yes.
That means they are not in possession.
No, sir. With regard to B schedule property,
Yes.
they want recovery. But with regard to certain portion of the property, see, originally they were in possession. Not originally they were in possession. They claim.
They never in possession. That's why court decide.
The question is, from the amended plain, it is clear that they were not in possession of B schedule property. So at present, there is no scope of this injunction restraining for interference with regard to B schedule property. But other property, what are the? Yes, that is the prayer B. Other than the B schedule property, there was a prayer restraining them from interfering the peaceful possession of the plaintiffs.
Then, my lord, why has
Para 18, you see, para 18 regarding B schedule property, it is admitted position that they want the recovery of possession. That means at present they have not obtained the possession, so there is no question.
I have in possession, they have filed a suit for my eviction.
You see, what is your prayer? Prayer C.
Prayer
You want a recovery of possession. That means you want from him
part of the property they have dispossessed. The part of
yes,
part
that
of the
that is what I am telling.
Yes,
This is,
yes.
so far C, that is schedule
that
B
means-
property is concerned, you are dispossessed.
Yes.
But with regard to
Yeah, I am in possession.
yes, A, that is the question.
Yes, that
My
much.
lord, both the court decided against him. Against him, my lord. Both the court decided. That's why I'm
For that,
pressing my lord
filed an
page.
appeal. Why
Maybe
what-
that means he is not in possession.
the court
No,
has
that
admitted the-
this C was also not granted, B and C not granted by the courts below.
Both the courts decided that he is not in possession. This is specific finding that has been affirmed by the trial court, appeal court, first appellate court.
That is wrong done by both the courts. My lord, the court relied on the ROR holding that this is a subsequent document, therefore my CSROR cannot be considered. My lord, your lordship, these type of documents.
Yes, record and order. Learned advocates for the parties are present. This application CAN 1 of 2023 filed by the appellant with a prayer for stay of the order passed by the learned trial court and the learned appellate court. The suit was filed by the appellant for a decree of declaration and permanent injunction. During the pendency of the suit, the appellant has claimed that he was dispossessed from B schedule suit property, for which he amended the plaint and sought for eviction of the defendants from the said property.
Moreover, my lord, he has not complied with the section order 6 rule 18, my lord. That has not been amended.
Thereafter, however, it is the claim of the appellants that although they were dispossessed from B schedule property, but they are in possession of the A schedule property, which is not considered by the learned trial court and learned appellate court, and their suit as well as the appeal was dismissed. After this appeal being admitted, liberty was granted to the direction was issued upon the appellant to serve copy upon the caveator respondent with regard to hearing of this application. Learned Mr. Maiti, learned advocate, Mr. Das, learned advocate appearing for the respondent number 1 caveator.
I have given the respondent number 1, 4.
Appearing for respondent number
1, 4, 7 and 7, 8, 9.
1, 4, 7, 8 and 9
yes.
Submits that the appellants were not in possession at any point of time, and the learned trial court and the appeal court, upon considering the same, has dismissed the suit as well as the appeal. Stop. Upon considering the order of admission by the Honorable Division Bench, this court is of the view that as the appeal is to be heard out, necessary protection should be given to both the parties so that the appeal does not become infructuous. Stop. As the prayer for status quo is prayed for by the appellants, this court is of the opinion that considering different judicial decisions where it is held that prior to passing the order of status quo, the court must ensure the status of the parties in the suit property. Stop. Thus, this court is of the view that at this stage, a special officer should be appointed to cause inquiry in the suit property as to the present occupations of the parties in the said property. Upon causing inquiry about the occupations or about the occupants in the suit property and the possession of the parties to this appeal, the learned special officer shall submit a report to this court. Such report, learned special officer shall upon notice to the learned advocates for the parties, and the parties shall cause the inquiry, take the picture of the entire suit property and prepare a map about the position of the respective parties in the suit property, if any, and thereafter submit the report. Such The such inquiry shall be conducted within 2 weeks from the date of communication of the order to the special officer, and the report shall be submitted on or before 9/1/2026. Let this matter appear on 9/1/2026. The special officer cost is to be borne by you because it is your application.
But both the sides.
No. It is your application.
But in the meantime, protection should be granted to us. You should not disturb my position. Your lordship has passed an order to that, my lord. I can say.
You see, whatever is there, in the event there is any subsequent development from date of this order and date of the filing of the report, such facts shall also be inquired into and submitted by the learned special officer.
The injunction application.
Let me consider the report. Okay, thereafter I shall consider.
When there was a document of title in my favor, your lordship knows the title.
No, you see, everything will be. This is an interim order. Okay.
No, the special officer subject to your lordship. What the special will go? You see position, my lord.
Whatever is the position.
Position.
After considering the report, I shall consider the interim. What interim orders you should get.
Get.
আমাদের তো একটা পজিশনে আছিস
মিডিয়েশন ফেল করে গেছে একটু বল না তাহলে স্ট্রেট করেছি ভুল করে But I am for the petition this matter, my lord. On the earlier occasion, a mediation was directed by your lordship, which has failed, my lord. And upon
In that case, my lord, we are appealing for the state. My lord, the case diary we need, my lord, to conclude this hearing, my lord, because
Okay. This is not a private case, but a state case.
Yes, my lord.
So case diary is required.
Case
and
diary is
private
required.
opposite party also not here, my lord.
But I have served them.
mediation has
Now
failed.
they have not come. My lord,
So let it appear
one
after
more
vacation.
thing- but one more thing, my lord. In the meantime, I am praying for a stay of the proceeding because the next date is fixed on January 5th of the next year. And my lord, we have to annex the supplementary charge sheet with
He
the
has
recent
not filed any
development.
grant application regarding that, my lord.
The
And
Record an order.
My lord, the order already the prayer is there in this matter only.
Learned
application,
advocates
which has
for
not
the
been
parties
adjudicated.
are present. Hard learned advocates. As the case diary is required for decision in this matter, let the case diary be produced by the learned advocates for the state of West Bengal. Let this matter appear on 13/1/2026.
In the meantime, my lord,
As the matter is sub judice before this court, parties may seek adjournment before the learned trial court, which may be considered.
my lord,
grateful.
problem.
I'm deeply pleased.
13 January. ঠিক আছে. And my lord, one kind, and your lordship is kind enough to add one line. The case diary may be produced on the next day.
Yes, I've recorded
Right.
that.
Oblige, my lord. Extremely.
But this my application, this that matter, my lord, where my lord mediation failed. And last occasion
For the respondent number 2, your lordship. Lordship, the mediation has failed, and that has been noted to your lordship on the last occasion. The lordship would like to put in a
For
affidavit.
the state, who is for the state?
Respondent number 2.
it's a complaint case.
Complaint
Complaint
case, your lordship, there is no state here. Lordship, appeal for the respondent number 2. We would like to rely on some documents and put in an affidavit. So, your lordship,
Then my
kindly
lord,
pass direction.
they will be extended till disposal of this case at
It
their
cannot be-
instance,
it
my lord.
cannot
This
be-
case
cannot
is
be
their
till-
instance.
It cannot
Otherwise,
be
hear
till
it out.
disposal. It cannot be till disposal.
Which is the next date?
My lord, next
The lower court, the judge is not sitting, your lordship.
no.
Yes,
The
record an order.
judge in the lower court is
My
not
lord,
sitting.
stay till disposal.
Lordship
Let
would
them
kindly-
let
Learned
them
advocates
at
for the
their own
parties are
fashion.
present.
There cannot be any stay till the disposal of this application.
Learned,
Based on this ground, if my learned
otherwise-
friend has a case, only then.
Otherwise, my lord, kindly hear it out, my lord.
learned advocates for the parties are present. Prayer is made on behalf of the learned advocate for respondent.
And last occasion, we
Respondent
also
number
prayed
2
for
for
this.
filing our opposition.
For filing the opposition.
This is
and
not a
relevant-
simple adjournment being created.
opposition and relevant documents. Let this matter appear on 14/1/2026. Stop. The interim order granted earlier shall continue till 31/1/2026.
My lord,
Grateful, your lordship.
I'm grateful.
না 12টার থেকে তো 11টা বাজেনি 12টা এখনো। হ্যাঁ আর কটা আছে? আর 2-4টে ডেকে দিন, কারণ 12টা অব্দি চলুক আর কি।
In this matter, my lord, I am appearing for the appellant. And Mr. Rajesh Sinha is appearing for the.
Okay, not today,
Then my lord, it will be taken up.
after vacation.
জাজমেন্টের উপরে জুডিকেটের একটা শব্দ আছে তাকে বাদ দিতে হবে অরিজিনাল সাইডে কোন দেখুন
Not today. Yes, 19.
20 to.
যেটা আপনাদের কর্পোরেশন
Twenty lordship, I am for the lordship respondent claimant, lordship, this is Mr. Rajesh Singh is there, lordship, this is 163 application. So kindly fixed after vacation.
Just making it not today, it will remain in the list.
Lordship, I am grateful. Grateful.
21. The LCR, I am for the claimant, my lord. My lord, the LCR may kindly be called, my lord.
20 item.
Item 21.
21. Yes, record an order. Learned advocates for the parties are present. Let the trial court records be called for.
With liberty to.
Upon receipt of the trial court records, the learned advocate for the appellant shall prepare the paper books.
Paper book has already been filed, my lord.
Okay.
But there are some documents, my
Okay,
lord.
okay. Let the trial court records be called for. Let this matter appear on 15/1/2026. Not today.
23, 24, 25, 6, 7, 58, 30, 31, 32, 33, 36, 37, 38, 39, 40. 1, 42 and 3, 44, 45 and 6, 47, 9, 1, 52, 53 and 4, 5, 56, 7, 8 and 9, 60, 61 and 2, 64, 65, 66, 67 and 68.
এই আর ডাকার দরকার নেই, আমি 5 মিনিট পরে আসছি আর কি। হ্যাঁ, 12:10।
এখন নয় উঠবেন সাহেব উঠবেন আর তাহলে আসছে হবে না সাহেবের কাছে জাজমেন্ট আছে অনলাইন ওই তো একদম হবে
এই 10 মিনিট পরেই আমি বসছি আছি।
the list,
Last matter.
but as not as not
Stop
it-
from the bottom.
Kind-
Lordship has
kindly
stop from the bottom.
The other matters will not take time.
Very
The
well,
other
very
matters
well,
are not
very-
for hearing.
very well. Then no, one matter has been marked as part hard, just above our matter.
Maybe to be mentioned does not mean hearing.
No. The part hard list, it is number 2, I think, Malad. Whatever, Lordship will take it up, Malad, as I thought I should inform.
Yes,
Malad. Mr. Mitro will be replying, I think. হ্যাঁ অ্যাকচুয়ালি ওটাই প্রতিদিন টপে থাকে, জজ সাহেবের অর্ডার থাকে, যে কোনো কারণ আর্জেন্সি আছে তো।
We talk from the bottom.
Grateful, Malad. We would wait, Malad. Grateful.
From the bottom.
Grateful.
Yes, I'm reading out the operative portion. Thus, this application GA9 of 2025 stands allowed in part. The defendant is directed to pay ad hoc amount of rupees 1 crore 50 lakh to the plaintiff on account of occupation charges, which is without prejudice to the rights of the parties. Such payments shall be made within 5 weeks from date. As this application stands disposed, parties are granted liberty to bring subsequent events regarding occupation charges in GA6 of 2022 by supplementary affidavit pursuant to the decision with regard to maintainability. The learned special officers shall file report on or before 15/1/2026 before learned regular bench having determination as per the above observations. Let this matter be placed before the learned regular bench on 15/1/2026.
Grateful.
I'm deep.
Pilot has been pleased to appoint learned special officer.
Special officers, if I'm not mistaken.
Yes. There is an earlier paragraphs with regard to occupation, persons who are occupying, that I have directed. That inquiry will be made, a report will be submitted.
Obliged.
Very well, Pilot. We'll look into the order and follow it.
Yes, no, disposed. This GA is disposed.
It is only GA9 which will
Yes, GA disposed. But the other application, the suit is pending. Yes.
So that will go before the regular.
Yes. Along with the report. Report and the payment, both. Yes. This matter, I think, is it that revocation matter?
Yes. The revocation.
Was that part heard?
Yes, it was marked part heard, Malad. Now, I have to give a reply only to the judgments cited by my learned friend. It's my application for revocation. Now, I had...
After you give your reply, you come with your written notes?
Yes, I will come with my written notes.
Vacation?
Yes, but so far the judgments are concerned, will be my Lord's pleasure to just distinguish the judgments in short in 10-15 minutes.
After vacation, you see, because the matter cannot be concluded today. So ultimately, when you reply, you do whatever you want, and thereafter, I shall fix a date.
If I recollect correctly, Your Lordship, we have filed our written notes of submissions.
No, let Mr. Mitro file.
Yes. We have filed our written notes of submissions. Your Lordship had requested that the written notes of submissions with all the judgments
written
should
notes
be made into a compilation and
compilation.
and
Written
given to
note,
Your Lordship.
list of dates, and the compilation.
Yes, Your Lordship.
He's opposing my revocation application.
Yes.
I had cited
Is your application?
Yes.
So after you give the reply and the written notes, it will be concluded.
Yes. But I have to distinguish the 11 judgments cited by learned.
Yes, I have cited a plethora of judgments on the maintainability, on the need for evidence, on the worth of their handwriting experts report, all of that. I argued, if Your Lordship recollect, for close to an hour before Your Lordship.
Yes. I heard it at length.
Yes.
There have been some delays on our part, so
several days you have argued this matter.
Yes, Your Lordship.
Put them in the note, my lord. Then the distinguishing factors of
You
those
reply,
judgments.
you just reply, and after a few days you file your notes.
Or she will give me a time in January.
Yes. Hey, record an order. Learned advocates for the parties are present. As the learned advocate for the applicant in GA. This is GA 2 of 2021.
Yes.
GA 2 of 2021 is to give the reply. Let this matter appear on. দেখুন তো ওই
It's pleasure to be a Friday, or I don't know. Is the original side matters then?
আচ্ছা
9th
মানে 13 তারিখে কি দুটোর সময় কিছু ফিক্সড আছে? 13 জানুয়ারিতে 13 বা 14তে কোনো ফিক্স আছে দুটোর সময়? 13তে নেই। ওকে, let this matter appear on 13/1/2026 at 2 p.m.
2 p.m. Deeply obliged.
আছে 13 তারিখে কি দুটোর সময় আছে? ও তাহলে 13 তারিখে দুটোর সময় হবে না।
ও
okay, let it 2 p.m. there is another fixed matter. Let it be either 3 p.m. or on the 14 তারিখে আছে। আর 15 তারিখ
না 14 তারিখটা হবে না, মানে can be 13th at 3 p.m. then?
Okay, let it be at 3 p.m. because it will not take much time.
Yes,
the reply.
Yes. For me, half an hour is enough.
13/1/2025 26 at 3 p.m.
At 3 p.m. Obliged.
Appear for the plaintiff in this matter. Lordship, by an order of 22nd September, your Lordship was pleased to refer the matter to mediation.
You are the intervener.
They are the intervener. But your Lordship, there has been no communication from the end of the mediator so far.
No, question is mediation proceedings commenced.
No, your Lordship.
But the mediator never contacted us. I personally.
No, question is there must be a report whether it has succeeded or failed or whatever it is. A report
Question has not even started, your Lordship.
Start, my lord. She never contacted any of the parties, my lord.
Anyway, let me seek a report then.
Lordship.
Record an order. Learned advocates. Where is the last order? Do you have the last order?
22nd September, yes, Lordship.
Hey, yeta dekhi.
The report was supposed to be filed by the 17th of November, my lord.
Learned advocates for the plaintiff and learned advocate for the intervener are present. By order dated 22nd September 2025, the matter was referred to mediation, and 17/11/2025 was fixed for report of the mediator. Stop. Till today, there is no report with regard to the mediation proceedings. Thus, this court is in dark as to what is the fate of the mediation proceedings. Stop. In the facts and circumstances, the matter stands adjourned till 16/1/2026 for report from the learned mediator. Let a copy of this order be sent to the Secretary High Court Mediation Committee. You communicate this order also.
Lord, if it may be recorded that the mediation never started, my lord. It has not yet commenced.
Anyway, let me see whatever it will be there in the report. I have to accept. Otherwise, I have to extend. If some time is sought for, I have to extend the time.
Grateful, man.
I am for the defendant.
It is appearing for what? Correction?
For corrections.
What correction?
But it has come up for none of our instances.
Key correction আছে? Oh, in the court-state title, in the High Court at Calcutta. Record an order. Record an order. The matter is put up for necessary rectification in the cost title. In the cost title, it is appearing as in the High Court at Judicature at Calcutta. Let it be rectified and made in the High Court at Calcutta.
Well, probably there is in defendant numbers one's name
also there is some minor correction.
Anyway, let them come and say they have not come. Great. পরেরটা দেখা যাক কেউ অ্যাপিয়ার করে কিনা।
Lordships and improved decree be drawn up expeditiously. Already 1 month has passed.
No, it will be drawn up because some of the decrees came to me in the month of July. Those judgments were passed.
Because it would be sent for settling and other procedures.
Because there is no appeal also, I believe. Is there any appeal?
There is no appeal, but we are.
But for that certified copy, definitely is obtained.
For the certified copy, we have applied, and we will probably file a review petition.
Okay, that shall be seen
before my lord.
Anyway, it will be done. That drawing, because certified copy and drawing up, you see, these July matters are now being placed.
Well, that happens as per the practice on the original side. We do seek directions for drawing up a decree expeditiously. If that is done, then probably within 7 to 10 days, decrees are drawn up, settled, and completed. That is what had been the practice which I have come across.
Okay. It is submitted by the learned advocate that the decrees.
May I only indicate that there is still 8 weeks that lordship was granted for.
You can always come out. Even after drawing up, you can come.
No, the 8 weeks is granted for you to comply the order.
Comply. In any way, they will not be able to file the execution if they want to. So 8 weeks is still there.
The decree.
Be drawn up.
The decree, if not drawn up, be drawn up expeditiously.
Well.
Item number 5, there's an ask for Professor Kumar Lord.
Lord, I appear for the plaintiffs number 1 to 9 and
I appeared for the plaintiff number 10, my lord.
14, my lord.
So what is the correction required?
Lord, perhaps this has come at the court's instance.
Yes.
Lord, perhaps this matter has come up at the court's instance, my lord.
কি আছে দেখি? Acha, record an order. This matter is put up for necessary rectification in the cause title in place and state of in the High Court at judicature at Calcutta. Let it be rectified as in the High Court at Calcutta.
Item number 3, my lord.
Item 3.
Plenty, my lord.
So the mediator's report is called for. That has not come.
Yes, my lord.
So I have kept it on 16-1.
16. Well, I record my experience, my lord.
Yes, record it, record.
I'm grateful, Lord. I'm grateful.
This is matter which is not getting off my back, man.
No, why?
I came.
No, why it is appearing?
I'll point out, my lord. It was my mistake, my lord. My lord, your lordship was allowed. But generally, my lord, we ask for, my lord, your lordship to fix the administration bond amount. My lord, that has been missed out, my lord. So generally, it's generally, my lord, your lordships give some.
That could have been obtained from the regular bench also.
Your lordship is a regular bench.
No. I don't have any determination now.
No, my lord. Now it is an order asking for your lordship's clarification, my lord. That is why, my lord. The application is for modification and or clarifying, my lord. So I cannot go to any other court, my lord. It's only for indication of the bond amount, my lord, because or else, my lord, they are not.
Alternatively, order modified.
But it's prayer A or
bond and surety.
My lord, if your lordship kindly considers prayer B, my lord.
Yes.
And I'll put in that, my lord. But that's a huge amount, but still, my lord, I'll try and put that in, my lord. That would take it to nearly 70 lakhs.
So what are you praying now? That
my lord, I am praying that let it be clarified. I would beseech your lordship to, my lord, some administrative bond, my lord. Your lordship kindly considers, my lord. I have said 10%, my lord. I've got so many orders, my lord. Generally, it is mostly most judges have passed, my lord, 10 lakhs. I've got several orders, my lord, at 10 lakhs, my lord, and even less amounts.
Wow, it comes to how much? 70 lakhs.
It is huge, 70 lakhs, my lord. So if your lordship, my lord, I would beseech if your lordship, my lord, generally we do such matters when it's generally it's 10 lakhs. If your lordship permits that, it's your lordship discretion under the সব কিছুতে এত যদি কথা বলিস জিরো বলে বল না না হয়ে My lord, under chapter 35, rule 15, my lord, it is your lordship's discretion. I have got the book also. Equity 11. And that is why I bought it. my lord. I should have asked for it, but it is my fault, my lord. Chapter 30, rule 15, my lord, it's just below that blue, my lord, you know, post-it. I should have been, absolutely my fault, my lord. I should have pointed out.
Anyway, let me see. Now let us see.
And generally, this is the way the orders are given, my lord.
So by 1st September 2025 order, probate was granted.
Yes, my lord.
No, not probate, letter of administration
Letters of administration, my
was
lord.
granted to the estate.
Generally, this is the way orders are passed if your lordship wants, my lord.
Yes, but that bond amount was not fixed.
Not fixed, my lord. And it's absolutely the discretion of the court, my lord.
Yes, record an order. Mr. Rai, learned counsel for the applicant, is present by order dated 1st September 2025. The petition for the grant of letter of administration being PLA 105/2011 was disposed and allowed, granting letters of administration to the applicant for execution of the last will of Kishorilal Jalan in accordance with law. Learned counsel for the applicant submits that although by order dated 1st September 2025, letters of administration was granted to for the execution of last will of Kishorilal Jalan, the testator, since deceased, but the amount of bond to be furnished by the applicant is not mentioned. Stop. In the facts and circumstances, this application stands allowed, considering the facts of the case and the period from which this application for grant of letters of administration was pending and the total value of the property. This court is of the view that it would be just and reasonable to direct the applicant to furnish a bond of rupees 1 lakh.
I'm very
Thus,
grateful.
this application stands disposed and allowed by directing the applicant administrator to furnish a bond under Rule 15 of Chapter 35 of the original side rules, High Court at Calcutta, amounting to rupees 1 lakh before the registrar original site. And
My testamentary jurisdiction.
Registrar, testamentary and jurisdiction.
My lord. And my lord, I think your lordship will also direct one surety at least.
With a surety of one surety of the like amount. This application stands disposed.
Very grateful to your lordship. my lord. Thank you. Grateful.
Your Lordship, I appear on
Lordship,
behalf
I
of
am
the
for the
plaintiff in this matter. Lordship,
defense.
just before my learned pen starts, I'll just indicate to your Lordship on the last occasion, your Lordship was pleased to pass an order. However, your Lordship, on the 21st of November 2025, when your Lordship directed that the matter appear today. Your Lordship, the embargo and the difficulty that I'm facing as of today is that on the said date, your Lordship, with the deepest respect, your Lordship did not have the roster for this matter, your Lordship. Now, your Lordship, should I, your Lordship,
Now question
in
is,
the decree, your Lordship, then one of the
no, what
grounds
have,
was
no,
that
no, no, this matter
this was
is,
not a part-heard matter, your Lordship. This was remanded by the Honorable Supreme Court
Lordship,
for
kindly
hearing on the amount or on the question. This was a suit for defamation.
Lordship kindly comes to the order dated November 21, 2025. We had mentioned, and my lord was pleased
no,
to
this
record.
order was passed in presence of both sides.
Your Lordship, order was passed
Both
in
the
presence of
parties.
both the parties, your Lordship. Probably my learned colleague failed to indicate to your Lordship, but your Lordship, on the said date,
May I
your Lordship,
answer?
your Lordship probably, with the greatest of respect, did not have the determination for hearing
That
it.
is
right.
the reason
As
we had
because-
Your Lordship,
mentioned.
No,
which
no,
is why, your
what
Lordship,
was the
without
direction of the Honorable Supreme Court that the matter be heard by the bench who has passed that order?
no, your Lordship, there was no such direction. The direction was to the extent that the learned trial court, which would be this honorable
Lordship, I
court,
fail to understand what my learned friend is indicating. That
I am indicating
I
to your Lordship.
that
I
is
am
what we are
indicating that
failing
your
to
Lordship,
understand,
this
because
matter has to
we
be
had
assigned.
specifically mentioned. We had specifically
Your Lordship,
mentioned.
they had
Okay,
mentioned.
let me see the order just.
Yes,
I'll
my lord
hand
had
over a copy.
heard this matter at length. Thereafter, we had mentioned, and my lord was pleased to record this matter as part heard, and hence this is appearing now. So I genuinely don't understand what is falling from.
Assignment something Your Lordship, what I'm indicating is now with the judgment of Justice Dipankar Datta, which has come in, which says that on the date on which the order or the decree was passed, if the concerned bench did not have the roster or the determination for hearing the matter, Your Lordship, that would be a ground for setting it aside. So, Your Lordship, should I win this matter, Your Lordship, the first point that my learned friend will take before the appellate court is this. So, Your Lordship, without
Because we have
Your Lordship, but their
the
consent
matter
is not
being assigned, and
consent.
thereafter the matter being specifically
Yes,
heard.
record an order.
Your Lordship, the matter was not assigned. Your Lordship, we'll get it assigned.
Done
It
it.
will be, or we'll approach
Advocates for the parties are present. On 21st November 2025, this matter was recorded as part heard on the ground that the arguments were heard by this court. Stop. However, as submitted by the learned advocate for the defendant, that as on 21st November 2025, this court did not have determination, the observation that this matter be treated as a part-heard matter could not be recorded. Stop. In the facts and circumstances, this court is of the view that in order to avoid the controversy, it would be just and reasonable to release this matter. Stop. Thus, the matter is which was treated to be part-heard is cancelled. The matter is released from the list. The matter may be placed before the regular bench having determination.
Your Lordship will also, probably Your Lordship recorded that at the instance of the counsel for the defendant, Your Lordship, plaintiff.
Okay, it is submitted, but যেখানে defendant করা হলো plaintiff করে দেবেন.
Grateful to you.
Grateful.
But, on the let Mr. Mitra.
So this was the last order passed.
I appear for the defendant numbers 1 and 2.
I am appearing for defendant number 3
Let the
in the
matter
matter.
be fixed on 12th December at the top for reply by the applicant, stroke defendant number 1, who is the applicant.
May I?
Order 7, Rule 11, he is the applicant. So let him finish. And
Lord,
give his-
I'll make a few submissions,
Just
Milord. I'll
wait,
indicate.
let me
Yes.
finish it off. But on the last day I was submitting
For defendant number 7,
36,
36, right.
the Sun. Order 7, Rule 11, filed by Mr. Abhijit Mitra, my lord, 1 and 2. It's a suit for partition. Declaratory suit was converted to a suit for partition. They have filed an application for rejection of the plaint, alternative prayer, deletion, and expunging
Order 6 as contemplated under Order 6, Rule 16. So I have argued at length. I have shown you from the plaint that the suit cannot be dismissed. Partial rejection is not permissible. And I have cited a judgment of the division bench presided over by Justice Shobhoshachi Bhattacharya, which deals with their point of Benami transaction and the bar of jurisdiction as contemplated under Section 430 of the Companies Act. It takes care of everything. And finally, what is required to be seen, how the property has come. If the property has come from a particular person, and if the partition has been sought for in respect of all the properties, companies of which are part of those properties, because he has substantial share, Miller, then obviously the partition suit lies. My first point was that let this application be dismissed. I have argued at length and I've cited judgments.
No, you have argued on what grounds are there for consideration under Order 7 rule.
Yes.
If that is complied with, then only the court can pass an order under Order 7 rule.
What the court has to see, not what they have argued or their point of defense.
You cannot go to the written statement.
No.
You have to confine with the plaint.
Court will have to confine only with regard to the plaint and the annexures contained in the plaint and the averments. From the averments, my lord, I have shown to your lordship, I argued at length, my lord, that yes, this is a partition suit. First of all, there is an order which they have accepted, did not challenge, which records a particular thing, which, my lord, quote unquote, that there is an existence of partition, Justice Sain's order. Then, my lord, I placed from the averments of from the plaint that existence or seeking partition, the relevant factors are present in the averment, in the plaint, and that has been duly averred, my lord. Therefore, prima facie, on the basis of averments made in the plaint, the suit cannot be dismissed. This has to go to trial. Now, my alternative argument was what the court can do, though I say it has to be dismissed. I mean, their application has to be dismissed because their point of Benami transaction bar, there is an exception, and the bar under Companies Act, since this is a comprehensive relief and not seeking any relief as contemplated under 241 or 242 of the Companies Act, operation or mismanagement.
Anyway, you have argued, you can clarify it in a written.
Yes, I will do that. My other alternative argument was, in the event if the court fails, then obviously there is a scope of relegating it, making it a preliminary issue. But that was my last argument. My first argument, the application has to be dismissed. And in any event, point of maintainability, whether suit maintainable or not, that itself can make an issue. It can be
Order 7 rule alone. Whatever is there, the court has to follow.
Absolutely. These are my submissions, my lord, sum and substance, what I argued on the last day. I hope Mr. Mitra will give a reply to that, my lord, only on point of law.
I was the plaintiff. My suit, which they want dismissed. Initially, what was my suit was declaration and injunction. Then I went to the appeal court. Appeal court said you converted the suit for partition. So I made an application for amendment that was heard, and the amendment was allowed by Justice Sen, saying that yes, you can convert the suit to partition. They got to challenge it. They didn't challenge it for 13 years. It has been remaining like that. They have not filed a written statement. Nor
to some extent, partition and administration also.
Yes.
All partition suit to some extent are administrative suits also.
Because my suit is because my husband, my case was the husband died suddenly without a will, and I filed a suit for partition of all his assets, which included some assets which he had put into company. Some assets were without company, some assets were in the company. So I have asked for everything, partition. I'm the widow, and he is appearing of one of the sons who's supporting me. And who's asked for who's made the application for dismissal of the suit?
None of the companies. None of the companies.
None of the companies have made. By my husband's younger brother, who says he has nothing to do. He has filed an affidavit saying he has nothing to do with the companies. And he has no claim. He says so. Now what he will say, I don't know. Everywhere he is changing his stand, depending on the convenience. His convenience cannot determine, my lord. What one stand you adopt, you have to is a universal stand. If you say I am so and so, you are so and so. You cannot change your color like a chameleon. Green ones, red ones, yellow ones to suit the court. Cannot be done. So, my lord, what Mr. Deb has said, the plaint has to be construed, no written statement, no affidavit. And what the government in the plaint is a demurrer application, the threshold. He wants my suit to go even before the evidence has started. For that, my lord, the abovements in the plaintiff have taken as correct. And I have a word that these are family companies. The source of fund was my husband, which has been accepted by the appellate court and the trial court. Now, if I amend the court, I amend my plaint based on the finding of the single judge of the trial court, final finding, which has gone unchallenged. Now they're challenging it. I have amended the plaint based on the finding of a judge who allowed the amendment, saying convert into partition suit. So he is saying the judge is incorrect by saying, indirectly he is telling your lordship that the judge is incorrect by saying that convert into partition suit. And not challenging that. He should have challenged it. He should have told the judge, you cannot do this. Why did I change into a partition suit? Because the judge told me, you file an application for partition, convert the suit to a partition suit. I did so and the amendment was allowed. By Justice Shomanishan, he allowed the amendment. He could have said no. Once you file a suit for declaration and injunction, you cannot convert to a partition suit no matter what the appellate court says. Because I am the single judge who has determination. He did not say that he allowed. And I converted the suit to a partition suit. And today, because I followed the, I am being told after 13 years that the suit is not maintainable. How can that be? The judge is wrong. The judge is wrong. The appellate court. Why we waited for 13 years? Why haven't you gone and appeal? Why haven't the Supreme Court is also the hierarchy is there?
Anyway, you have taken these points. You will clarify it in your written note.
Yes, I have got the written note. Your lordship gives a date. I will hand over the written note.
Yes. After the reply, only the written note.
Only the written note. Nothing more remains.
No.
And reply, my lord, with greatest of respect, my lord, on a limited point that not on facts, on law, which I said. Otherwise, again,
once I do not intend to.
I do not know how he has come. He has never.
I'll indicate how I have come, but I do not.
No, he has come walking.
Which defendant?
Defendant number 3.
Defendant
And
number
before since my learned senior friends are making submissions, I don't want to interrupt. Once they are done, I'll make my submissions.
Yes, yes.
Application is made by defendant number 1 and 2. Kindly see. How is he appearing for defendant?
I'll answer that. How I'm appearing.
Whether you are supporting or not.
I'll indicate.
Whether you are supporting the applicants or you are supporting
I'm not supporting anyone. I'll come and I'll indicate what is the premise and why my presence is required, because it's the company.
Defendant number 3 is
It's the company. AK Computech Private Limited. And I'll indicate why I have come in.
Okay.
What has been submitted by my learned friend is that he's for the plaintiff. I do not want to interrupt. Let him complete.
No. Why is he will first explain why he hasn't filed any written statement for 13 years. Why he hasn't filed a written statement for 13 years? And why?
See, just a minute. This is, you see, first of all, this is not your reply. Reply is to be by the applicant.
Applicant.
Okay.
Yes, it is a complete different.
Yes, Mr. Mitro is not giving the reply. That means I have to hear your cause.
Indeed, I'm very grateful.
That
And I'll
is the
indicate
thing.
why.
Why?
I am the company who is getting affected.
Because you see,
so without hearing me,
you have not submitted.
Lordship.
Mr. Mitro's application, either you have to support or you have to oppose.
In effect, I am supporting. I have to support.
Now the question is, now it is the time for Mr. Mitro to give the reply.
Yes, understand that.
Now
But
you have
Mr.
come to
yes,
understand.
I am a late entrant to my lord.
Anyway, you please submit.
I'm very grateful.
Let Mr. Mitro give, because it says not for reply by the applicant number.
Now at the time of the reply, you have come to the picture.
Indeed.
Anyway.
Indeed.
Very late.
Indeed.
Very late.
Very late, but I have not missed the bus. So,
when the matter was argued, were you present?
No. That's
recently you are recently engaged to appear in this application.
Yes, I am.
Just to delay the whole
It's not
thing.
about delay. If it's a proceeding which is not maintainable at all, that I have come to assist the honorable court. I've been
this suit
instructed.
is not maintainable at all.
At all.
Very
at
well.
all.
You
And
submit.
I'll indicate that.
Understood,
There's nothing to understand. There's nothing to
could not
understand.
follow. I thought because this is a reply, but you see, unless he is the applicant, how will he give the reply?
That's right.
It is for Mr.
That's
Mitro
right.
to give the reply.
Somebody comes in.
So today he has to give a new cause.
So basically, it's a reopening of a case. Everybody
It's not
understands,
really
Milord.
reopening of a
Let him
case.
submit, Milord.
I'm sure.
Anyway, please submit.
The moment I.
He is Bangla's Bagh, so he let him submit. I'm not.
Yes, that you have to accept.
Milord, before I start, I must indicate this, since I've come in very late at the stage, Milord, when it's a stage of reply for the Order 7, Rule 11. I'll indicate what is the premise of my argument, Milord, before I proceed any further. Your Lordship will first take, because it was submitted by my learned senior friend, that he's the plaintiff. It is his suit which was amended to be converted into a partition suit, which the parties were not agreed by perhaps, and that is why no challenge. That's the submission. What has not been indicated is, my lord, pursuant to the Order 6, Rule 17 being allowed, my lord, the main point which has not been addressed. Your lordship will first take up the prayers before I indicate the amendments carried out in the plaint. Can you take a page 45 once? Today, my rights are going to get affected in a proceeding where, my lord,
Sorry, Akmeet. My lord, I'm sorry, my lord, extremely sorry that I'm troubling my junior friend, my lord. There is an issue, my lord, possibly lordship would kindly consider. Kindly see the name of the defendant number 3 who is being represented by Mr. Bagh, my lord. There is an issue which probably needs to be gone into, my lord.
What is defendant number 3? There's a limited company.
Computec Private Limited.
Yes, yes.
Now, my client, the defendant number 36 is the director. He's a director. Still, he is a director.
36.
Yes, whom I represent, and I made my submission.
36.
Yes.
So item number 36 is the director.
Yes. Still, he is a director. He is present in court.
Okay.
So he did not.
He never submitted that he was with the director.
Not only that, my lord.
Well, I have not,
for the company.
I have not concluded. I have not said. Just opened my mouth. Let me, my lord, clarify what I want to say. Then obviously, if I have done something wrong, my lord, then lordship will other side will indicate. Obviously, Mr. Mitra will indicate.
No, in what capacity you see? This is
that is exactly what I want to say.
This is the son of the plaintiff.
Son of the eldest son of the plaintiff.
Okay, now
he is the director.
Very well.
He did not
author whether director of these or director of so many other companies.
Director of 3.
Director
of 3, who is being represented by Mr. Bagh right now.
So in this
he did not authorize anybody.
Question is whether he is agitating his personal rights or he is confining himself to that particular company.
Well, that's right.
That's right. Confining to defendant number 3.
Right.
But so what your client is concerned, he is not confining to defendant number 3.
So, Malad,
all
his rights. That's right. So, Malad, when the company, somebody appears, Malad, there has to be an authority. There has to be a resolution.
Yes.
That's right. So everybody knows it. Kindly ask his advocate on record to produce in court how or who has empowered or authorized him to appear. That is a very basic thing, Malad.
Yes,
just I cannot appear and say I appear for such and such. When I appear for a company, there is a procedure everybody knows it, Miller. Let him produce that in court.
Very well, Miller. Then I should not make any submission.
Coming and saying
because my advocate.
Then I'm adjourning the matter. You bring that affidavit. File an affidavit.
Indeed, because Miller, today I'll indicate why. No, it has to be. Because you have taken this point. I have to address this point.
So you know.
Otherwise,
You know that why?
I have been instructed by Mr. Obijit Sarkar.
What
he
is
is
the
very well. What is the authority? What is Milord the challenge? I'll answer that.
Have you entered appearance in the suit? Defendant number 3.
Straightway coming to make submission.
You have entered appearance.
Yes, they have.
But only thing is this: you did not file written statement.
Yes. So for that, Milord, I have to take instructions because my instructing advocate.
That's on instruction. I am saying this. My client is present. And
his client is not my advocate on record. I have to wait for the instructions of my advocate on record.
Record and order.
No authority. I come and argue the matter.
Advocates for the parties are present. Mr. Bagh, learned counsel for the respondent, defendant number 3, AK Computec Private Limited submits that he is appearing in this matter for the first time and he has authority to represent.
No, my lord, I'm instructed.
His
authority would be, my lord, the advocate on record. Obijit Sarkar, no, I will not. I'm not the counsel. I'm not the advocate on record.
To represent AK Computec Private Limited.
My lord.
Mr. Bagh further submits that he is supporting the applicant in GA 11 of 2025 for certain grounds.
Lordship.
Mr. Deb, learned advocate, representing the defendant number 36,
And
Sub-
I am adopting Mr. Dev's submission.
No. You see, so far the company is concerned, he is the person who will have the best knowledge.
My client is one
Okay,
of the director.
Mr. Deb, who is appearing for defendant number 36, submits that his client, Jagrit Bhutoria, is the director of AK Computech Private Limited. Thus, it is to be clarified under what authority
That's right, my lord.
the advocate is engaged by the said company without knowledge and consent of the director.
Well, if he can produce it, he can argue. I have no issue.
In the facts and circumstances,
Where is the authority and
and
power of the advocate?
affidavit
Let him
regarding
produce.
the authority to represent in this matter be filed on the next date with all relevant documents enclosed. Let this matter appear on 9/1/2026.
I'm very deeply pleased. Very deeply. Mr. Obijit Sharkar was not keeping well, my lord. He has told me, and that is the reason, my lord, is not here today. Otherwise, I would have answered
Anyway,
immediately.
whatever it is, you bring it on record.
Lord,
In the
may I
affidavit.
only seek this clarification? Your lordship has recorded.
The affidavit which is to be filed on the next date be also served upon the other parties.
My lord, we will. May I only, my lord, seek this clarification? Your lordship has been pleased to record that I, on instructions, because my lord,
Yes,
I'm the
yes,
counsel, I can't really.
Yes.
Very deeply, very deeply.
You go now.
Bro.